So I'm having fun with you here. I said, she's not. So.
All right. The 14A District Court for County of Washington, State of Michigan, is now in session. All those having business before the court draw near, the Honorable Judge J. Simpson presiding.
You may be seated. Okay. They're all quick. Ann Arbor Commercial Realty versus Scott Sendes.
Good morning, Your Honor. For the record, Jim Walsh-Smith here.
Scott Sunday, Your Honor.
All right. Okay, hands on everybody. Sorry.
We're pretty close to resolving this matter. We'd asked the court for another adjournment for 30 days. It's actually to the benefit of the defendant. He's removing, I don't know if this court remembers, but
Yes.
he's almost done removing everything, figure another Buffalo Bank difference.
Okay. Is it, you agree with that, sir? All right, very good. 14. Okay, I will adjourn the matter to October 14th,
Thank you, Your Honor.
2025, 9 a.m. All right, thank you, folks. Strong Future Homes versus McFarland. Good morning, sir.
With your permission, we'd like to adjourn this. Ms. Lee and I spoke last night. They had asked for those recertification records going back. We have produced them, which prompted her to ask a series of questions, which our client is researching the answers to.
Got it.
I don't know, but of course, this is a case worth trying to work out. And Ms. McFarland suffered another loss in her family. And so I don't want to do a trial with her while she's grieving.
Understood.
So if we could set it out maybe a month and
Okay.
hope against hope that we can actually resolve it without your help.
Okay. October 14th, 2025, 9 a.m.
Thank you.
All right, thank you, sir. New Park Ridge Apartments versus Tubbs.
James Fink for the plaintiff. I thought she was going to come and give us evidence that Mr. Gardner's Otis had changed, which would launch us into some kind of discussion of a COP. I could do a couple of things here if you want to give her more time to show up.
Okay,
But,
we can do that.
and I'll check the sex offender registry addresses while we're waiting.
Okay, all right, then I'll pass this time. Barnes and Barnes versus Ariel Daniel. Did they check in?
They did not.
Ariel Daniel or Jason, or I'm sorry, yes, Werner Kemper. It's a lot of words. Werner Kemper.
If you recall, they had moved,
Yes.
and then they were disputing the charges. You said for today.
Right.
I have talked with Jessica, the manager. The charges that I've seen ledger, they are what they are.
All right.
And it's 20 rent 275 cost for 3095. But
All right. I'll do it this way because and we're sure that possession's been surrendered.
Yes.
Oh, okay. Then I will at this time then enter the money judgment for the amount paid for 3095 on this case. And I'll do that by default. All right. Thank you, sir.
Is your one required when you said one?
You'll need to send one in. All right. Okay, thank you. Beal Properties versus Jason Mitchell.
Quick docket detour. When defense says, "Can we pass this matter?" It's court speak for, "Hold this case for a few minutes while we find the human attached to it." Happens a lot in busy call calendars. Judges keep the assembly line moving.
Is this Mr. Lloyd?
Yeah, this is Miss Lacy and Mr. Lloyd.
So somebody showed up for Libby.
Yes, Miss Lacy is here. You can see Mr. Lloyd.
So Lacey and Lloyd are like in a room talking.
Well, Mr. Lloyd's in the hallway. I can see his backside. Don't see Miss Lacy.
Yeah, that'd be a conversation. No, I don't want to. Court calls the estate of Earl Samuels versus Jonathan Samuels. Good morning, sir. Your name, sir? All right. This is in effect, and just so that we're clear on the record, it would be effectively a hearing to determine whether or not a order of eviction should be entered, but that had been entered. So I'm hearing your objections and whether or not I should let that stand, sir.
Yes, Your Honor. Because it was not obtained according to proper procedure in multiple ways. If it is appropriate for Attorney Marcus as the acting for the personal representative, if it is appropriate for him to use the landlord to obtain the order of eviction, he didn't follow the requirements of the law the way, because he just tried to continue a case from nearly 2 years ago that wasn't at all the same legal entity, even though they inappropriately called it the state of Earl Samuels 2 years ago. Was actually, Dad was alive on cell. Now Dad died and there actually is an estate. So to come to the court as Attorney Marcus did last month and say that he's now the representative of the entity that obtained the order, the judgment or the court, conclusion 2 years ago. No,
But sir, you need to understand that there are numerous occasions where there's a judgment entered by a person, being or a live person, who subsequently passes away. That case is then basically renamed with their estate. And it happens from both sides, particularly in with landlord tenant. It can happen from the plaintiff side, it can happen from the defense side. So I don't know that that's necessarily an issue for me.
well, it is, because now I'm a 50% heir. So I have a totally different legal standing than I did initially. So, and under the law, I have.
Yes, but that your standing vis-a-vis that property would have been taken care of by the probate court.
Well, that's part of my argument is the probate court should be handling this.
No, they don't have to. As to the possession of premises, there is actually, in one reading, there's either I have jurisdiction over it or there's concurrent jurisdiction between the probate court and this court. So either of the courts can act.
I thought it was pretty narrow, the landlord tenant law saying that the ER in a case like this can only act to evict after the property, it says conveyed, says it's 705, 605 or 071H.
Legal checkpoint. Waiving the preliminary exam skips the mini hearing where prosecutors must show probable cause. It doesn't mean case over. It means the case jumps to circuit court faster. Smart move if there's a deal brewing or the evidence hurdle is low. Would you waive here or force the state to put cards on the table?
Where it's narrow in what it allows the district court to do, because
The district court can act where a personal representative is properly before the court, but the authority for the personal representative to act has to come from the probate court. I can't confer their authority to act.
well, the bottom line is that Attorney Magnus was obligated to do things in a more deliberate way rather than just try to use something from nearly 2 years ago. And you're saying that sometimes a ruling for before that can be continued on, but I would argue that because I'm a 50% heir, that
But you would have had to have gone to the probate court, right?
I'm in the middle.
Because the very fact that you're an heir to the property doesn't matter. What matters is that because there's going to be somebody that's going to be able to act regarding that property. And that's going to be the estate. And whoever is the personal representative of the estate is going to make those decisions, despite your status as heir. If you have an objection to what they're doing, then you go to the probate court, you make your objections to the probate court to what they're doing.
and I am, and I'm in the middle of that, and there's appellate cases that relate to this. So there's many things going on that Attorney Magnus tried to go around that to involve this court by saying that he was continuing something from 2 years ago, which is significantly more complicated than he.
Did you seek a stay at the probate court to this court's action?
I filed a couple motions for reconsideration. I'm filing.
And the motions for reconsideration is because the probate court has ruled against you.
Right, because Attorney Magnus said things at the hearing that were not true, and the judge didn't have an opportunity to hear.
Which judge was this?
The new Oakland County Probate Court Judge Tracy Richards, who placed.
So Mr. Magnus went in, said what he said with his magic words and just fooled the judge.
Well, she was giving deference to Attorney Magnus and my sister's attorney. That
You are not going to, one thing that you're not going to do.
Yikes, bench warrant issued. Translation, Miss Court and the judge orders your arrest. Add $25,000 cash bond and you've got real leverage to ensure the defendant shows up. Sidebar, this started as a competency issue. If a defendant can't understand the proceedings, the court can pause the case for evaluation. Not showing up to that, bad combo.
I don't know, Judge Richards. I don't know. But I will say this, if you are, courts give deference to parties when they come in. All right. If you are going to indicate that a colleague of mine on the bench, despite being in another county, has shown some bias to your detriment, if you're going to make that argument here, the only thing I'm going to tell you is you better bring it. Because if you're going to make that accusation, you better bring it.
The judge was proceeding as though Attorney Magdas and the attorney for my sister would be obligated to tell the truth. And she assumed that when she asked them direct questions, that they wouldn't say things, that there's material facts that contradict. So that's all parts of my motions for reconsideration, because there are.
Has she ruled on your motion for reconsideration? Has she ruled on your motion for reconsideration? Okay, so you want this court to, so why didn't your motion for reconsideration include a stay of these proceedings?
It referred to these proceedings.
That's fine. Why didn't it include the request for a stay of these proceedings and or a request to prevent the personal representative from doing specific things until such time as the judge could consider?
I asked for multiple things in the motion for reconsideration. I don't think I used the specific language to ask for a stay of this proceeding, but I'm actually, it's 2 weeks today from the hearing.
So, sir, let me explain something to you, because built in, when I was a bit shocked when the parties appeared the last time by a number of things. One of the things that I was a bit shocked about was that you did not reside in the premises. And let me tell you why that's important. Because once the court determined what it determined here, that there had been a hiccup in trying to figure that out, the great fear for the court is that somebody was displaced from the premises to their house, and that something that happened shouldn't have happened. That harm isn't really in existence here at this time. You couldn't have resided at the premises because our order of evictions have a procedure in place that allows you to get before this court prior to the execution of any writ or order of eviction. And that is basically a 72-hour hold after the posting. That's the first thing. The second thing is that, from my understanding, there haven't been any things removed from the premises.
Well, but there was harm. They removed 2 vehicles which had value, and I really need the money from those vehicles. So.
Okay, so if you believe.
That's part of the eviction.
So, okay, so if you believe that the eviction was improper, that you lost some property, then you would have to go after the estate. That doesn't come here.
What I was asking for is just to stay the eviction until we resolve things in the probate court. So.
I don't know why I do that.
Because Attorney Magdas didn't follow the procedure in several ways.
And that is precisely my point. Other than these vehicles that you say have left, and I don't know anything about the vehicles, there hasn't been the harm that would normally inure to somebody who has been evicted in this instance, because property hasn't been removed. So I'm able then to give you the hearing as to whether or not to allow the eviction to stand. And in fact, give you, as I indicated at the last hearing, frankly, more time than you would have gotten otherwise to make whatever argument you needed to make to the court.
The argument is that the probate court should control things, and if not, then
Then if you believe that, sir, and that this court wouldn't have jurisdiction over a property that is venued in the 14A district, if you believe that, then that argument needs to be made to the probate court to stay the eviction or to prevent the personal representative from acting on the eviction.
I'm in the middle of that process. I've been
So
clearly,
if you're in the middle of that process, then I should allow this to stand. And then you argue that before the probate court.
that I think there's reasons to not allow this to stand because Attorney Marcus didn't go through the proper steps to.
I know Attorney Magnus is just a very bad individual. I get that, but that's not a basis upon which I made my decision.
Well,
I say that.
He's, as personal representative, he's obligated to be impartial, and he's doing things that favor my sister.
He does, I would imagine that he's doing things consistent with his fiduciary obligation to his client, that being the estate. Which there are going to be those which are involved in the estate, because it always happens, that aren't going to like that. So the real issue is you don't like what he's done.
Well, from my first conversation with him, I told him that the essential thing was that the farm stay in the family, and he said that he agreed with a basic argument that the person who was trying to buy it 6 months ago didn't have a good case to be able to continue trying to buy it, but then he changed his mind. So, and this eviction then helps him proceed with the sale that he changed his mind about he changed his mind in July. In June, he told me that the person trying to buy the farm from 6 months ago.
Who's the personal representative of the estate?
Timothy Flynn, the person that Attorney Marcus represents.
Yeah. So why do you have so much animus toward this man?
Why does he have such animus towards me? I was living at my parents'
All right.
house more
Well,
than half the time.
apparently I struck a nerve.
That's a hard no, and here's why. If a person was extradited to Michigan on these charges, the court isn't about to risk them crossing state lines again. Even with testing arranged elsewhere, flight risk optics matter. Question for you. Should courts ever allow out-of-state travel after extradition if compliance has been good, or is that a bridge too far?
Are you listening to what you're telling me?
Your Honor, if someone
Are you
changed the law.
listening what you're telling me? Every sentence has begun with his name. He's an attorney representing a personal representative of an estate.
Yes, and he's obligated to be impartial, and
He's obligated to do his job for his client.
and
That's his obligation.
and that would potentially include me. I was the one who worked to create much of the wealth that still remains in the estate. It was my sacrifice for many years. So for him, he's doing things which will diminish the wealth of the estate.
And why would he do that?
Because it's quicker. He's doing things that will resolve the estate more quickly, which is what my sister's attorney wants, rather than to achieve I mean, for example, my parents' house is not in great condition on the outside, and I have things prepared to do work to achieve closer to full market value. But Attorney Magnus doesn't want to do any repairs and just wants to prepare it for sale as quickly as possible. So he's going to sell it to not a typical buyer, a flipper person who will.
Is he doing that against what the wishes of the personal representative are?
No, he's doing it because that's what the personal representative wants, but it's against. what makes
Exactly.
sense for the-
Exactly. That's his client.
I also have an interest in the estate, and
You do. And if the decision is made that the property is sold, I'm presuming you'll get your fair share.
yeah, but my fair share of a diminished sale significantly. Imagine the difference between the
Then you
house.
have to argue that to the probate court.
Yes, I'm in the middle of arguing many things to the probate court. And
Okay.
You're saying, so a key thing, Attorney Magnus on June 30th changed the locks and.
There we go.
Staying more than.
He went out there himself and did it?
What?
Nothing.
He
Go
did. What?
Nothing. Go ahead.
What?
Go.
Can I reply briefly?
Yeah, no, you've been very good at being quiet, so we'll let that continue a little longer. Go ahead.
So on June 30th, without any notice, without telling me that I shouldn't be staying at my parents' house more than half the time, he came and changed the locks. All my things were there. He saw that my food, my computers, my clothes, everything was there, my legal papers. Imagine if someone just came to a residence where a person's living and locked them out, and then.
But you weren't living there.
I absolutely was living at my parents' house more than half the time, and I had Google Maps timeline showing in the 100 and.
It's a different house, Your Honor. We're talking Farmington House.
So
There's an eviction
we're
case.
talking about Attorney Magnus's actions, which have
Oh.
been impartial, which I keep referring to him because he has demonstrated, and the way he said at first that he understood how important keeping the farm in the family was to me, and how the legal argument to sell it seemed reasonable. Then he changed his mind without justification, and all of this is the whim of Timothy Fuller and Steve Magnus, rather than what's really right for the value of the estate and respecting what my dad wanted. And people refer to the estate as being intestate. There is a will. The same people who refer to no will.
Can I just say this? All of that, you've got to take me for the probate court. I told you at the first hearing, if I wanted to be a probate judge, I would have been. I'm not dealing with the will,
But
if there is one.
you're going along with what he did.
Okay, yeah. I'm going to tell you what, I don't think I've ever met Attorney Magnus before. I don't think I've ever laid eyes on him before that last hearing. What I saw his appearance, I had no idea who he was. So don't come before this court, because I know where this is headed because of the way that you make your argument, and claim that I, for whatever reason, have some bias or some other interest in what he says to me. He has said nothing in this hearing, and I see huge problems with your argument regarding this writ.
What about problems with the way he obtained the order from you? Because
Which I'm going through the process right now of correcting.
I would argue that the way the law is, the order isn't appropriate yet, because like the 600-547 is narrow in what it allows the district court to do as far as evictions. And I think I've cited it correctly.
When you say it's narrow, what do you mean?
Well, that's what I want to refer to is the 600-5407 has just one reference to an estate and a personal representative, and it says after, I mean, it says after sale and conveyance. Oh, I have it wrong. 5417 is it? So here, 5714. I had the number one, 600-5714. 1H, when a person continues in possession of premises sold and conveyed by a personal representative under license from the probate court or under authority in the will. So that's when the law that let you sign the eviction order would apply.
No, sir. You need to read the other parts of the statute. That is one instance.
Well, that's the only one that I saw referring to an estate like this.